Hey guys, I'll give us a minute to confirm sound and then I'll go ahead and jump in. I think I have sound, just a second. Jump in. Okay. All right, so I just wanted to go live really quickly just to talk about the latest development with the case. So the state rested today, and then Judge Boyce brought up an issue of a clerical error where when the state amended the charges in February of this year, they got the dates wrong on the charges. On the murder charge for JJ, they said between September 8th and September 9th. So what I want to do is play the segment of that part of the hearing in case you haven't heard that. I'm going to play it at 1.25 speed, just in the interest of time. And then I looked up the criminal rules and the jury instruction that Judge Boyce referenced. And so then I'll just talk about it briefly. Just keep in mind, I have no legal training. I just looked at the criminal rules and the jury instruction. So, okay. Let me switch.
All right, thank you for the argument. The court's reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving JJ Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of JJ Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that JJ Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes. Why don't you, I did say a lot there, and Mr. Pryor offered to say a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, holds the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right. I know there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment is not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against. And if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
Okay, so I looked up the criminal rules that Judge Boyce referenced. The first one was Criminal Rule 7E. And that reads, the court may permit amendment of a complaint in information or indictment at any time before the prosecution rests if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced. So this basically says you can only amend an indictment before the prosecution rests, and this was brought up after the prosecution rested its case. The other one was Idaho Criminal Rule 29. I think A is probably most relevant before submission to the jury. After the prosecution closes its evidence or after the close of all the evidence, the court on defendant's motion or on its own motion, meaning the court itself, like Judge Boyce could make its own motion, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. If the court denies a motion for a judgment of acquittal at the close of the prosecution's evidence, the defendant may offer evidence. If the court dismisses an offense, the court must consider whether the evidence would be sufficient to sustain a conviction on a lesser included offense. So I don't know if that is potentially something that they could go for. I just don't know. But it basically says, again, after the prosecution closes its evidence and rests, and then the defendant could make a motion, or the court itself could make a motion for acquittal for insufficient evidence. And then Judge Boyce also referenced jury instruction number 4. This was on the first day of Chad's trial, and the audio quality is very low, but I'll play it. I'm not even sure I totally hear, but this goes to the point of, like, if they had said on or about September 8th and 9th, maybe, or on or about, let's say September 8th, maybe there would be more wiggle room, but it sounds like because they said on or between September 8th and 9th, that may tie Judge Boyce's hands behind his back. So let's just play that.
Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, proof need not show that it was committed on that precise date.
So it was an instruction about the difference between on or about or on or between. So, again, I don't have any training. Sorry, my hair's crazy. I don't have any training in any of this, just a modicum of common sense. But I did like some quick searches. I even asked ChatGPT about it. But I'm not making any predictions. I'm just looking at the criminal rules that Judge Boyce referenced, and obviously, thankfully, he knows the law better than I do. And I do know that he has had a consistent pattern of protecting these defendants' rights to a fair trial, excuse me. And so I know that he will do that. And if there's any room that he has to be able to keep the charges without, risk of mistrial, I'm sure he will do that. But that has to be the, I don't know, just the gravitas must be weighing very heavily on everyone. So I feel for everyone involved, this is just a really difficult situation. It was very sad watching Lindsay Blake's, hands just go over her mouth. Like, they've worked so hard for this state, and I can't imagine what they must be experiencing or what JJ's family must be experiencing as we await Judge Boyce's decision on this. But, hopefully cooler heads will prevail. I'm still confident that Chad will not see the light of day as a free man. But, that doesn't ease the anxiety of everyone who's just awaiting this decision right now. So I'm not going to take questions just because this is so outside my domain of expertise. But I did just want to go live just with like looking at the criminal rules and the jury instruction that Judge Boyce proffered. So they are supposed to reconvene at 4:30 Eastern, 2:30 Mountain. Yeah. Anyway, so we'll see what happens. All right. Bye.